criminal defense attorneys get cases dismissed? Hi, I'm Javier Alatorre. I'm a criminal defense attorney and trial attorney in Tucson, Arizona, and I help people fight for their freedom and protect their future. All right, let's get on to the video. Well, first of all, we need to understand what a dismissal is, right? So dismissal is an order of the court that basically kicks the case out of the court. The case does not continue after the case is dismissed, right? It's basically kicked out. Now, so basically there's two ways to get a dismissal. Both the defense and the prosecution have a right to file a motion to dismiss the charges or dismiss the prosecution of the case. The order of dismissal can have two different effects, with and without prejudice. When the court issues an order dismissing the case with prejudice, that means that the prosecution cannot bring the charges again. If the dismissal is without prejudice, then they can refile, depending on the charges, depending on the facts, depending on the timing. They have different times or whatever, but generally, if the charges are dismissed without prejudice and the statute of limitations applicable to the charges has not lapsed, then the prosecution can refile it at a later time. Right? Now, so when can a defendant file a motion to dismiss? There's a common misconception that the lawyers actually can get cases dismissed and they won't bring them back and stuff like that. But the rules of criminal procedure limit your lawyer's ability as to what reasons your lawyer can ask for an actual dismissal of the case. For example, your lawyer can challenge the sufficiency of the complaint. It means the sufficiency of the charges presented. Your lawyer can say, well, wait a minute, the way the charges are worded does not provide sufficient notice to my client to understand what he's being accused of. The way the charge is written can be confusing to a jury, or it can affect the defendant's right to a unanimous jury verdict because it charges like plan A, plan B, plan C. So separate jurors could potentially find them all guilty of the charge, but under a very different set of facts, right? So another way your defense attorney can move to dismiss your case is when the charges do not constitute a crime. Maybe the allegations lack certain elements of the offense they're trying to charge you, and basically the argument is, well, even if he admits to everything they say he did, there's no crime. So dismiss it, Your Honor, right? But your defense attorney, contrary to what a lot of people think, your defense attorney can't file a motion and say, oh, Your Honor, the evidence is sufficient to prove those charges, so dismiss it. You can't do that. Can't do that. The only person who can do that is the prosecutor. The prosecutor can, on prosecutorial discretion, move to dismiss for many reasons, one of them being, I don't think I can prove my case. Right? So your defense attorney, instead of actually filing a motion and saying the state has no dismiss it, Your Honor, what your defense attorney has to do is contact the prosecutor and convince the prosecutor to dismiss the charges. And that's where your defense attorney has to get really creative. And of course, he needs to do his job. So what does a defense attorney do to convince a prosecutor to dismiss your charges? Well, there's different ways. For example, there's something called diversion or deferred prosecution. So basically, your defense attorney will review your case and then he can negotiate with the prosecutor a non-trial disposition, right? A resolution of the case without trial that involves some form of agreement, right? So for example, diversion or deferred prosecution, depending on which court, you basically enter into an agreement with the state. And you say, okay, in exchange for you dismissing this case, I will take a class, I will go and take these, anger management classes, or I will go to a psychologist and go to therapy for so many days, or domestic violence counseling. And after we complete the domestic violence counseling, I'll dismiss the case. So basically, it's kind of like a contract. You have a list of things that you need to do that the prosecutor wants you to do. If you do those, once you provide proof that you did them, he'll dismiss the case. So that's one way, and your lawyer can actually negotiate that for you. Another way is on misdemeanors, there's something called a misdemeanor compromise. So certain crimes, certain misdemeanor offenses can be dismissed pursuant to misdemeanor compromise. There's a list and the rules, but anyway, what your attorney has to do is basically negotiate a deal with the victim. And you get permission to speak to the victim, because the victim doesn't have to speak to your attorney if he or she doesn't want to. Usually what I do is I call the prosecutor and say, hey, I want to see if a misdemeanor compromise is available in this. I would like to speak to the victim. Please convey my request to the victim to talk. If the victim agrees to speak to me, the prosecutor will say, yeah, give the victim a call. So I call the victim and talk, hey, the rules, the statute say, we can actually negotiate this out. So why don't we make you whole for your damages? It's a weird technical settlement negotiation in a criminal case. It only happens in misdemeanor cases. It doesn't happen in felonies and certain misdemeanor cases, not all types of charges. And what would happen is if you guys come to an agreement, there's basically kind of like a contract that's signed and the prosecutor, signs off on it usually. And then we file it with the court. There's some, things things that we have to say to the court and stuff, and the court dismisses the case pursuant to misdemeanor compromise, right? Another way you can do it is a deferred guilty plea. This is similar to diversion or deferred prosecution, but what the prosecutor wants you to do is to plead guilty first, and then what happens is they don't enter the guilty plea, but you signed everything. You do the whole thing. You plead guilty, right? But then that thing stays in paper in the judge's folder. The judge is part of the whole thing, and then the entry of the guilty plea is deferred for whatever time reasonable is for you to do whatever you need to do, counseling, whatnot, right? If you don't comply with those requirements, if you don't do whatever they're supposed to do under the agreement within a specified period of time, or if you violate or whatever during that time, the guilty plea gets entered. So it's over. You already pled guilty. So that's another way it can be done, right? But the main dismissal that you see on TV is when the prosecutor dismisses the case. It's like, yeah, we're going to lose. Prosecutors do have a duty to dismiss the case when they don't think they're going to win. So how do you do that? Well, your attorney gets discovery during the process, right? So when your attorney receives the evidence, he or she will review it, see what weaknesses the case has and what potential arguments you have, right? And sometimes we find some good stuff. And then we talk to the prosecutor, say, hey, prosecutor, you're going to lose this case. Dismiss it. And the prosecutor looks at it. No, I think I can win. But tell you what, I think you have a point. Here's a plea offer, right? So plead to a lesser charge or something like that, or I'll give you an agreed upon sentence, hopefully something better that you can get if you go to trial and lose, right? And then your attorney needs to kind of evaluate that, discuss that with you. And then, if you still want more, but you can go back. So during those plea negotiations, we prepare something that's called a plea deviation request. So it's basically a fancy letter that your lawyer will write telling the prosecutor, look, I reviewed the case and this is what you have. This is what you don't have. This is why I think I'm going to win. This is what I'm asking from you. Sometimes we ask for a different kind of plea, right? But there's been times when in my deviation request, I say, hey, you know what? As a minister of justice, I am asking you to dismiss the case. You do not have a case. You have a duty to dismiss when you can't win, right? So you need to make an ethical evaluation of your case. Some prosecutors will do that. When I was a prosecutor, I really looked at it. If I didn't think I could win, if I thought I was going to lose, I dismissed the case. I didn't waste anybody's time. Dismissal. The job of a prosecutor is not to get a conviction. The job of a prosecutor as a minister of justice is to ensure that justice is done. But the prosecutor also has to make an evaluation of the value of the evidence and how fair it is to take you to trial based on all these facts, right? So that's how you get a dismissal based on they have no evidence, right? But some prosecutors won't do it. Some prosecutors actually believe that they'll win some cases, right? So what do we do in that? Well, we have something called a settlement conference. Sometimes we say to the prosecutor, okay, you won't dismiss? No. Okay, so this is the last plea? Yeah, take it or leave it. Okay, let's do a settlement conference. Now, if the prosecutor agrees, sometimes we can force the issue with the judge, but you usually want the prosecutor to agree because you want a voluntary participant in a settlement conference, right? And what happens is we tell the judge, hey, judge, we're going to set a settlement conference. We want to try and talk in a more formal setting, see if we can settle this. So we find a different judge from the same court where your case is, and we present to that judge our positions, our respective positions as to why we think we're going to win and why we think the current plea offer or the current state's position is not appropriate and what we think the state should do. And in lieu of that, what kind of plea, if any, our client would be willing to accept, right? And then the state presents its own memorandum and to that judge, to the settlement judge, which is not your trial judge. And he or she will tell the judge, hey, no, this is where I think we're going to win, and this is where I think the plea offers on table is fair. This judge is not your trial judge. This judge has nothing to do with your case, and this judge cannot tell your trial judge whatever said in that settlement conference. So those are really, really, really good for everybody involved because we get to pick the brain of an actual judge, right? A judge that does cases like yours all the time, right? And we said, well, Your Honor, I think if he forces me to, I'm going to file a motion to preclude all the evidence. He's going to lose all this evidence. And if we go to trial after that, he's not going to have any evidence, right? And then he's going to tell the prosecutor, tell the judge, no, Your Honor, because there's this case law that says that he doesn't win that motion. And then the judge will tell us, well, I mean, if I had that, I think I probably, based on what you're telling me alone, I think I probably ruled this way. Or sometimes I've had judges says, it's a good motion for both your parts. I mean, I think 50-50, either you can win, that you both have significant risk that you're going to lose that. And that motion is going to be heavy. Right? So I had a case I remember. My client was charged with discharging a weapon in city limits. Technically, he confessed because when the cops came, he told them, yeah, these guys were shooting at me. right? They were shooting at my house, you know? So they didn't believe him. They just didn't believe him. There was an altercation. There was a bunch of stuff outside his house, but they just didn't believe his claim that he was shot at first. And while in his home, right, in front of the garage door of his home in his driveway, he pulled his gun and shot back. He didn't kill anybody. Nobody got shot, but shots were fired, right? So the prosecutor was adamant, no, we're going to trial, we're going to trial, we're going to trial. So what we did, I did my job. I hired an investigator. I did some investigative work. I found some 911 calls that were not disclosed by the state. I don't know if they didn't have them or they just didn't look for them or what, but there were several 911 calls that were not disclosed by the state. One of them was the call that was made by my client's family. In that phone call, on the 911 call, you could hear how my client got shot at, and then he responded with the exact number of shots that he told and admitted he had actually made, right? We had that recording. So I said that for a settlement conference. And that's where I brought the recording. That's when the prosecutor found out that the recording existed. I also hired a ballistics specialist to walk the house during the daytime to figure out if we could find any evidence that there were shots, because he was shot at and he didn't get hit, but behind him was his big ass house, right? So, I mean, it's a big target. Something could have been there, right? So the expert walked the property and stuff. There was an impact on the garage door that he said looked clearly like a projectile impact from a bullet. So I got him to prepare an opinion on that. Those are my defenses. This is a self-defense case, justified shots. There's no way they're going to win this case. What happened? Case dismissed, right? By the prosecutor. Prosecutor filed a motion to dismiss. I didn't file a motion. I can't file that motion because my challenge is on the value and the weight of the evidence, not on any legal issue that's been violated when the charges are presented. That's how you get your case dismissed. You put enough work and investigation in the case where you put a prosecutor in a situation where he or she has to decide, well, can I win this case? They don't need a lot to win a case, okay? But every now and then we get good evidence. It's like, can I win this case? I don't know. And then finally they have to make a choice. And sometimes they make the right choice and dismiss the case. Remember, a lot of people tell me like, well, they have no evidence. That's not necessarily true. Particularly if you've been charged, they have evidence. The evidence might suck, but they have evidence. Because remember, like even a he said, she said case, what he said and she said is evidence. Whether it's enough to convict you or not, that's up to a jury, okay? Or a judge if it's a bench trial. So that's the issue. Like they have no evidence. All they have is what she said. Yeah, that's evidence. So another thing you need to understand is there's a lot of movies and stuff that, you know, oh, the defendant file a motion to preclude and gets all the evidence dismissed and the case gets dismissed. That can happen, but does not necessarily happen. There was one case I had that I remember distinctly where it was a DUI and the cop had no reason to stop my client, like zero. I challenged that, right? I moved to preclude, right? I had my own evidence and I told the judge, you know what? This guy's lying. It's not true. It's impossible. There's no reasonable suspicion. There's no probable cause. He shouldn't have stopped my client. The judge agreed. But because it was an illegal stop, everything that happened after that was unlawful. It was obtained by violating my client's constitutional rights. So what happened? Evidence got precluded. But the state didn't dismiss. They appealed. And they were trying to continue stuff and, you know, and just kind of keep the case going. So I filed a motion and said, well, Your Honor, they won't dismiss. That's up to them. But let's go to trial. Either they dismiss or we go to trial. We had some argument stuff, so eventually the judge agreed, yeah, so it's your choice. You dismiss pending appeal or we go to trial without the evidence. So they dismissed, but they dismissed without prejudice, right? It's because they were hoping they were going to win the appeal and then bring back the charges, right? So we won the appeal. They didn't bring back the charges. And that was it. And that's how criminal defense attorneys get criminal charges dismissed. I hope this video has been helpful. If you or somebody you care about is facing criminal charges and you need to talk to somebody, description down below. You'll find my booking information and my phone number. Feel free to give me a call. I'll give you a free consultation, see if we're the right fit. Good luck with your case. See you in the next video.